The next case is City of Parker versus Wilson. Counsel, you may proceed.
May it please the court, Eric Krebs on behalf of the City of Parker, Florida, reserve 5 minutes for rebuttal. In this case, Your Honor, Ms. Wilson, the appellee, brought a 2-count complaint to declare a city park, or what the City of Parker has determined to be a city park, to be, whether it's a private or public park, is to count 1. And then in the alternative, for count 2, if the court were to decide it was a public park, for them to decide if the activities the city was placing on the park were beyond the scope of allowed uses. In this case, there was also an injunction sought to prohibit uses beyond those outlined by some of the developers after the city in 1976 had already approved the improvements to the park based on their belief that it was a dedicated public park. And also the appellee sought to enforce use restrictions that were contained in a February 1976 document related to the park after the city had voted to improve the park. By the trial court ruling that the park is private, in count 1, count 2 was effectively moot, which eliminated all of the judicial activity in the case. However, the city had also filed a motion for summary judgment at the same time as to count 1 to rule that it is a public park, and as to count 2 that the uses were appropriate to be used within the public park.
Counsel, are we sure that we have jurisdiction over one part of a big piece of litigation going on? Why do we have jurisdiction over it now?
You have jurisdiction, Your Honor, because count 1 effectively mooted count 2, which eliminated all of the judicial aspect of the case in the lower tribunal. That, obviously, we can bring an appeal based on the approval of count 1 in the appellee's favor, but also under 9.110K, because there was a denial of our motion for summary judgment, that we're also allowed to bring that within the confines of this. Yes. So in this case, Your Honor, we believe the court erred in many different ways. If you've read our briefs, they're pretty extensive. Primarily, as to count 1, we believe that the plat that was approved in 1955 that has the word park on it without more by case law determines that that is a public park. The city in 1976, which had been established.
So how come that didn't mean it was a park for the people that were in the neighborhood?
We're on the term without more. It's is according to the Florida East Coast Railroad Company versus Worley case. It's a park without more determines it's a public park. You have to have some intent of the dedicators prior to an acceptance to show that it was a public park or a private park. In this case, we believe that because it just said park on it.
I'm sure there's lots of gated communities that have some kind of common space that might be labeled park on a plat.
And that's not this instance, Your Honor.
Okay.
So the initial argument was that this was a public park from the beginning. And then in January 1976.
If somebody developed this neighborhood and they had some lots that they called park.
Right.
So we're determining whether, when they said park, whether it was a park for the people in the neighborhood or a park that became part of the city.
And Your Honor, the plat itself dedicated public streets and roads and other aspects of the plat. It just left the word park without the word private or public or for any other determination of what that park is for. The precedent in that case from 1905 says that a park without more is determined to be a public park. In this case, at the time.
But for decades, the city treated it as a public park.
Correct, Your Honor.
They built things on it.
They improved it, they built things on it, they maintained it, they policed it. In January, and the important thing is the timing. In January of 1976.
So when they were building the lift station, there was no issue, where they had to pay the residents, there was no taking.
No, correct.
No one alleged to taking.
Correct. In
And
fact,
they added a boat ramp, right?
there was a boat ramp existing in 1976 where the city council voted to improve a road to the boat ramp on the park and also to survey the park. It was right after that there was some objections made by some of the lot owners, and there was a clarifying dedication that happened about 5 weeks after the city had voted to improve the park. However, it's important to note that from February of 1976 until this case was filed in 2022, there was never a dedicator or a lot owner that came up and said, you cannot do the activities on this, it is a private park.
Right, and just to be clear, what kind of order, when we say improvements, we're talking millions over the decades? I mean, and
Yes.
assuming, setting aside statute of limitations, if this weren't a public park, would the city have a counterclaim against the landowners for all of these millions of dollars of improvements?
Possibly, we believe the acquiescence of the 40-plus years by the dedicators and the lot owners shows that this, and that was the basis of our Miami Beach improvement, the Eastern Realty Company case. There's 2 Miami Beach cases in this. Ours is Eastern Realty, the other side is Miami Beach Improvement. That third DCA case, which was based on the Catch case, which is also the basis of the Miami Beach Improvement case, says that, acquiescence alone can create a public park. Even in that particular case, there was a private park dedicated. It stated specifically on the plat, this is for the private use of these lot owners. The city came in and did multitudes of work, improvement, and so forth, and no one ever complained about it. And then later on, they came back and said, no, this should have been a private park, it's not a public park. So in that case, they said that this acquiescence based on Catch showed that this became a public park. In this case, even if it wasn't a public park to begin with, once they began improving it without any objection of the dedicators or anyone else within the lot, and it continued to do that, and it was millions of dollars. They had $1 million grant to improve the boat ramp in the 90s. They put in a stormwater system that helped the flooding in the neighborhood. It's surrounded by streets that are all dedicated to the city and all improved by the city. There's no private lot.
Let me ask you a question here. Your acquiescence argument would not apply to the expansion of the lift station, right?
We believe it
After
does.
Hurricane Michael, how would that? Because that occurred in what year? Did they expanded it and added the fence, the roof, the lights?
Well, speaking of this particular case, count 1 was not dealing with the expanded use of the lift station. It was just on count whether it was public and private. The count 2, which was asked for, was if it's public, then does the uses, do they violate what would be a public use? If this had become a public park from 1976 forward, then it can be used for a public purpose, residential purposes, without the need of an expansion or anything. So it becomes public land, and so because they increased, basically they put a fence around it after Hurricane Michael destroyed everything over there. They put a fence around it, and these are all requirements by the state, we believe, to shore up this lift station that is to the benefit of the Applee and everyone else in the surrounding area. We don't believe that expands the use at all because it's already a public park with already a lift station that's been there since 1983, as well as, that's a small portion. It's less than 3% of the entire scope of this park, and it's still being used for residential purposes. It's separate from that AT&T case, for instance, that talks about a cell tower that was used for commercial purposes and so forth. This is still residential purposes of a lift station that provides benefit to those surrounding lots and owners.
And there's plenty of land in the park not being used by the lift station that the public can come, or the lot owners can come and do whatever they want to vote in.
Yes, Your Honor.
Have a picnic.
The evidence that was presented in the summary judgment showed that there's about 97% of the park is not taken up by the lift station. So there's a parking lot for the boat ramp, but the laws in Florida related to park usage would, I think, allow that recreational access to the water, as well as there is still an area that is pure grass, and at some point throughout the years there's been picnic tables and concrete benches and other things that have been put in there to keep that area alive as a true park, as that goes.
Well, when we look to the Flowers case from our court, which talks about, the public dedication, and in the first prong, the intent to dedicate the property for public use, that can be revoked, right? And we have some dedicators who sought to revoke it. Would the revocation need to be unanimous among all of the dedicators who originally dedicated the park for a public purpose?
Yes, Your Honor. A couple things with that. Prior to this attempted revocation, if you determine that clarifying dedication was an attempt to revoke this public dedication that was done after the vote by the City Council, the Kirkland case versus City of Tampa from 1918 and the Weber versus City of Hollywood, which is a second DCA case, say that there has to be a consent and by all of the dedicators and all of the lot owners. And in this case, there have been over 102 deeds issued from the time this third amended plat was approved until February of 1976. All of these deeds are in the record. So they would have to go, and whoever's an owner would have had to also tried to revoke it. But it also had to been revoked prior to acceptance. And it's very clear that the acceptance of this on the record was a vote by the City Council on January 6th of 1976 that said, we're going to improve this and survey it, and therefore it is a public park. It was not until 5 weeks later that one of the dedicators with a power of attorney for a few of the other dedicators, but not all of them, put in this clarifying dedication. It's also important to understand that those city council meetings, she never appeared at those city council meetings, and the only counsel that was there was actually the attorney for the Applebee's predecessor in interest to this house. So he knew at that point that all this was going on. And then after February 22, I believe, in 1976, there's no public record of any kind where there was a contest by anybody to prevent the city from what they were doing.
All right, and so to follow up on that, even if that had not been an express acceptance, was there acceptance by act and, going back to the maintenance, the lift station, and all of the improvements to the property?
Correct. The acts of the city and all of the public that use it, and I know that the Appley will bring up the case related to, mere use by the public is not enough to create a public easement. However, those cases are distinguishable. In that case, it was about, I believe that's the one where they were walking across land. The public was just walking across land to get to the water. There was no actual actions by the city to improve or do anything or to accept it until after that dedicator had actually deeded that to another person. So that revocation happened before the city itself did anything, pardon me. In this case, we have a vote, we're gonna improve it, but we'll hold off for a minute. Then one of the dedicators with a power of attorney does this clarifying dedication, says, no, we meant it to be private. And then they say, well, we don't believe so, we're gonna continue forward. And then from there on out, no actions occurred. And in fact, Ms. Wilson bought her house in 2002 and no action occurred. And she knew from the predecessor in interest, whose attorney was at those hearings in 1976, that there's been an issue for this property for 26 years. So when she actually was on proper notice and used some of these in a hearsay fashion, we believe, to try to show that at least one dedicator was upset about it, but then stopped. And we believe that the millions of dollars in time and money that have been expended by the city and the acquiescence.
You're into your rebuttal time.
Oh, I'm
just so
sorry.
you know.
I didn't realize that. I apologize. I'll hold 3 minutes for rebuttal and I'll step back.
Okay, thank you.
Good morning. May it please the court, Julia Madalena from Hand Arundel Harrison Sale, and I represent the appellee, Joyce Wilson, also a resident of the city of Parker. What I think this case really boils down to is what Judge Henry identified in his order granting summary judgment in favor of Ms. Wilson. He identified that the third amended plat was not a public dedication of the park, and he found that for several reasons. One, the streets were dedicated to the public, and the park was notably absent from that dedication. The label park clearly appears on the plat itself. If the dedicators intended to include that with the public dedication, they certainly could have. Two, the dedicators, developers reserved unto themselves the riparian rights. That is the waterfront park that we're talking about. That evinces their intent to keep that private, keep that to themselves as the fee simple landowners. Three, they reserved unto themselves the right to add additional restrictions to the community. Again, evincing an intent as the fee simple owner to retain rights as it relates to that park and also for the owners of the plat. And we know from McCorkdale and many Supreme Court cases, the effect of accepting that plat by Bay County and recording it in the official records is that those lot owners have what's called a private easement in the common areas shown on that plat. Now, private doesn't necessarily mean exclusive, so that's where we come into this analysis of what makes it exclusive, but we know at a minimum that Ms. Wilson has a right to use that park for park purposes, and nobody has a right to come in and alter that use and use it for non-park purposes, and again, that's McCorkdale is an excellent example of that. So if we look at the plat and we determine there was no initial public dedication, and remember the case law tells us intent, developer intent. This is not what the city wants, it's what the developer, the fee simple owner wants.
Counsel, how many years were there between that developer intent and the filing of the lawsuit?
Your Honor, yes, there were decades, but there were events that happened in between them that are very significant. So if the plat was not an initial public dedication, and in 1976, the city comes forward and says, we would like to consider whether this is public. They actually asked the city attorney in their meeting minutes to give an opinion as to whether it was public or private, indicating they weren't sure. And they ultimately said, well, we think we'll get it surveyed, we think we'll pave a boat ramp. Guess who came forward? The lot owners, the developer. They came forward and stated unequivocally in that clarifying dedication that if there was any ambiguity, it's being resolved. And it's being resolved by a majority of the developers who signed
What year
that.
was that?
That was 1976, February 4th, that was recorded.
Yeah, a lot of history after that, too.
That's correct, Your Honor, but is it the taxpayer's burden to keep the city in line when it continually ignores express affirmations that no public dedication is occurring?
Well, there are consequences for not trying, maybe.
And Judge Henry took that into account. If you look at his order, when it comes to removal of encroachments, he deemed that the passage of time rendered anything constructed prior to 2017 would not be removed from the parcel. So there's a balancing there. But at the end of the day, we're condoning a local government's taking without just compensation, which is a violation of the Constitution. And we're expecting the taxpayers to pay out of their pockets to sue their own city to say, stop infringing on my personal property rights, my vested property rights.
So when did the taking occur, if there was a taking?
Well, it's difficult to say because what happened in 1977 is they built underground sewer pipes. Is that a clear taking of the park for park purposes for the public? I'm not so sure that it is. Fast forward, perhaps, is it 1996 when they got the grant, but it doesn't actually say when that was installed. I think if you look at the pictures of this park, which are in the record, you'll see it's a relatively small parcel. It's a gravel parking area, the lift station off to the side, but it's relatively sleepy, right? It's tucked into this neighborhood in the city of Parker that you have to wind through the streets to get to. And so the question of at what point should the owners have really been triggered? Well, let's talk about 2014 when Mayor Musgrove sent a letter on city letterhead announcing that the park was private and that it was for the benefit of the lot owners and that they had a choice. They had a choice of whether they were going to give the city their interests. And only, I believe, 16 out of 51 lots did so. Ms. Wilson did not. And she was clear that she was not willing to do that. And so the city collects these quitclaim deeds. And they actually announced, well, we didn't get unanimous approval. We're abandoning this park. Ms. Wilson's affidavit in response to their summary judgment motion outlines they stopped mowing, they stopped maintaining, they left. And so all the owners at that point are really assured we're on the same page here. Our interests are not adverse, they're aligned. And so when does that change? Well, it changes in 2021 when the city comes in, new leadership, new approach, and says, never mind, this is ours again. And in fact, we've gotten a few quitclaim deeds from developer heirs, and I can touch on why that doesn't change the analysis, but certainly from Ms. Wilson's perspective, at that point, she's realizing we're not aligned. The city is changing course. They're claiming rights to this property that they've since disclaimed. They're building on the lift station substantially. There are lights shining into my home and fences going up in my park. And that is what precipitated the lawsuit being filed in 2022, which is extremely timely when you look at what happened in 21 and she immediately filed suit the next year.
So the fences and the lights to the lift station, weren't those things required by state law? I mean, they had to put those on, right?
I don't think there's any evidence that that was required by state law. What I've heard and what the record I think suggests, if you look at the transcripts, is that it may have been required by insurance to maintain insurance on the lift, but I have never seen a citation to any law that would have required that.
And just again, interest that was adverse to the landowners, I think we've got to go back a few decades. I mean, we're talking about paving the road to the boat ramp and surveying the property. I mean, when someone comes on your property and starts surveying and building roads, that's not adverse to your interest?
Well, I think when we look back in time, the theory advanced by the city is either it's a public dedication, which again is intent, which we've had 2 affirmations that that was not the intent, all before official action was taken.
Was that unanimously expressed by all the dedicators?
I think Ms. Bleckley's clarifying dedication, which was the majority, is an accurate reflection of the intent of the original plan, which is a hearsay exception. She's absolutely allowed to put that out into the official records. And that's what Judge Henry essentially found, is that it all goes back to the original plat. If there was never a public dedication, the city doesn't get to ride on those coattails. And what are they left with? Adverse possession and the quitclaim deeds. And we've certainly briefed that they do not meet adverse possession requirements. They have no color of title that they can demonstrate, no good faith reliance on that. They have no return filed with the property appraiser, which is required without color, and that's been on the books for decades. And they never did any of those things. So if adverse possession's out the window and there's no public dedication, then they have these quitclaim deeds, which matured, much later. They were obtained anytime after 2014 all the way to 2021. And those quitclaim deeds, you don't take anything more than what the person gave you. So for a lot owner, even if they could divest the easement from their lot in relation to the park, which I question, it runs with the land in relation to the plat. But even if they could do that, the city steps into their shoes. And they can't wipe out neighbors' easements without a taking with just compensation. So these continual actions, and I think repeated over time, new actions, right? New decisions being made by the city, they're restarting this clock for Ms. Wilson, and certainly raising it to her attention that at one point, for many years, they were aligned in their expectations about the park. And then when that really changed and became clear to her, I think that does restart the clock for her to raise these issues.
How does this litigation and our decision affect the rights of lot owners who are not parties? So there were how many lots and only one person and not even her spouse represented? I think what you said at the hearing was we're not adjudicating the rights of the other lot owners, we're only adjudicating the city's rights and responsibilities, but how can you do that without also affecting all of those lot owners, some of whom might not like it? Why shouldn't they be parties?
Yes, so the analogy that I gave the judge at the trial court level, and I think is borne out in some of the old Supreme Court case law, I think City of Miami, which unfortunately there's several of those, but the court was dealing with the developer and the city, and they actually opined at the end of the opinion that the neighboring owners didn't need to be included because their rights in relation to the park are not changing. So a declaration that the park is not public means those lot owners that are neighbors of Miss Wilson, they can come and do whatever they want. And if they came in tomorrow and tried to build a house, that's an entirely separate issue as to whether are they honoring the park purposes, are they acting within the scope of their private easement, but they retain all those rights. And so I will say, I think an argument's been made that the clarifying dedication sets forth, in addition to saying that there was never a public dedication, it sets forth restrictive uses as to the parcel, no motorized vessels. To be clear, if you look at our complaint, we've never asked for a ruling that there can't be motorized vessels. That's not what she's seeking in this case. Her claims are truly between herself and the city as to whether this is a public park. And you'll see in her affidavit, she talks about the Fish and Wildlife Commission had posted it online after Hurricane Michael as a public boat ramp. And there's vehicles everywhere. There's people parking in the road. There's trash. So she lives right there. And so it does have a real impact on her, this determination of whether it's public or private, even if it's not necessarily gated off, for anybody to access. And she has to honor her neighbors as well. She couldn't go in and exclude them.
Well, let's talk about those other silent, not present before this court neighbors. If we were to agree with you and say, yes, this is a private park, whose duty is it to maintain those improvements on the property? Does that go to all those silent homeowners and community owners and Ms. Wilson now? Do they divide that up, or does the city have a duty to maintain that?
Well, from 2014 until 2021, the owners did maintain the park. That was when the city had abandoned it. As far as the improvements, Mr. Krebs for the city has raised that in a motion to stay, and I believe that transcript is in the record. And those are some of the issues Judge Henry said we'll have to get to those. There are unanswered questions that come down the line, but I don't think maintenance of the lift station falls on the owners. If you're talking about mowing grass, generally the easement holder does have a burden to maintain and make secure the property to protect, against any liability concerns or something of that nature. But it falls to each person. And what's interesting is that the plat guarantees the lot owners a private easement, whether it's exclusive or not. It's there and it's enshrined. The case law says a public easement can be coexisting, right? So it's okay that it's coexisting. So whether one goes away, I don't think it changes the lot owner's standing and their normal obligations in relation to the park. I would only just we did touch on the express dedication or lack thereof. Just a couple comments about the case law. The Worley case is from 1905. City of Tampa, which is from 1915, v. Kirkland, that they actually commented that the holding in that case was very narrow and limiting, and the rest of it was dicta and should not be followed. And that was a subsequent Florida Supreme Court case. So I think that's important to acknowledge. We also have more recent Supreme Court cases that talk about the test for public dedication. The third
Are they in conflict with those earlier cases?
Well, I think Worley, if you take out the sentence from Worley that if you just look at Platt, it's automatically public, I think that is cast aside in favor of the test set forth where we're looking for expressions of intent,
Did the
actual
Supreme Court
expressions.
say that? Did they say we're receding from that case, or that has no legal effect?
The quote, and it is quoted in my answer brief, I quote the provisions of the City of Tampa, and I apologize, I don't have it on hand, but essentially what they determine is they look at it and they say, to the extent this court opined about formation of public dedications, we think that was dicta, and I think suggesting it was kind of overreaching, and they say it only applies to its narrow set of facts. And again, we're looking at intent, right? So if there's any ambiguity, we look to extrinsic evidence. Well, what's that evidence? It's the dedication, it's the words used, it's the clarifying dedication, it's the statements of intent that all point to no public dedication. And so for the city to override that purposely and intentionally, I think is setting a problematic precedent. And then saying, because you, the taxpayer, didn't stand up and stop me, the government, that I get away with this. And I do understand there's been a passage of time, but I think many activities happened after that, and certainly more recently. As far as we touched on adverse possession, and I only have a minute left, so I'll just touch on the quitclaim deeds. My only comment on that, I think we touched on the lot owners not being able to divest that from their property. I think that's an issue. But again, you step into those shoes. And as far as the developer heirs, McCorkdale, the Supreme Court case from the 1950s, tells us again that the developer retains the fee unless they've transferred it by some sort of transfer right. So the plat does not give anybody title to anything. It gives easements. And so the developer retains the fee. And in McCorkdale, it was a private person, and they sold off a portion of a beachfront park to a private entity who opened a hot dog stand. And it was 16 by 10. And the court said, that is invasive, it's intrusive, and it's not a park purpose. And it's not the commercial use. The AT&T case touches on this. It's not about the commercial aspects, it's the non-park use. And just because it's sanitary service, just like it's a cell phone tower, where someone can call 911, that's what AT&T was about, they said that's not sufficient. Thank you so much.
Thank you.
May it please the court, there's a lot to unpack. The McCorkdale case is highly distinguishable in the fact that there's no public entity involved in that case whatsoever. The public park uses are are much broader. If there's any ambiguity in a plat, it goes as to whether there's public uses. The law states very clearly that ambiguity goes in the favor of the public. So if there was an ambiguity that needed a clarification, which is stated in the clarification, to clear up this ambiguity of the word park, these few of us say this. Well, if there's an ambiguity, the case law that we briefed clearly states that goes to the public dedication. Judge Henry did say that there are things that aren't addressed in this case that may have to be subject to another case, but he didn't say they were within the bounds of his decision related to who's going to have to do what with the improvements that are there. If it becomes a private park, there's a lift station that is not going to be used by the county, by the city any longer, right? So that's going to impact all the neighbors who have a vested interest in that, which they also should be part of this. Also, in count 2, Ms. Wilson did request judicial action, and in her summary judgment, I believe, but definitely in the complaint, that the use of the park not be inconsistent with all of those uses that are detailed in the clarifying dedication, that it be removed, all of these things be removed, it turned into just grass and no motorized vehicles, which impact everybody in that lot, everybody surrounding that, that use it for those purposes. The statute of limitations are interesting because Judge Henry goes through this thing and says that all of these uses are adverse and they should have been brought by the dedicators back in the day, but they weren't. However, they're permissive uses, so adverse possession doesn't count, which is sort of contradictory. All right, if there's an adverse use that eliminates statute of limitations for her to bring any of these claims based on whether it's, these things need to be removed and it's a violation of our easement, they would also exist to the statute of limitations as to whether this is a public or private park, right? I mean, if all of these uses are adverse for 46 years, then that statute of limitations and latches is way, way gone. Adverse possession would have actually probably kicked in, if you use the plat as the color of title, which the city believed in good faith was a city park, then 7 years after that, that's when adverse possession would have kicked in and they actually owned the park at that point, which is one of our defenses. The ex parte communications from the mayor are.
So what about the 7 years where the city abandoned the park? and
Well,
said-
that's what I'm saying. There's
it
no.
said residents, you have it, yours.
Well, that's not how a dedication and acceptance works. A mayor can't eliminate public property. There's no ex parte allowance by a mayor or a police chief. I think there's some reference to police chief in there. They can't
Well,
come up.
certainly in the first instance, he can't say it's yours and it automatically becomes theirs, but if they say it's yours and then the city does not exercise dominion over it and lets the neighbors run the thing for 7 years, why is not adverse possession?
You
there?
cannot have adverse possession against a governmental entity. The Florida law states that specifically. So even if they didn't do anything for a long time, there's plenty of cases out there where there's acceptances that are 40, 50 years after the fact, or they've accepted part of something and then they expand it later, and they say that, these acceptances can go in different stages and so forth. But there's no way that these people can then come back and say, well, I used it. In fact, there's cases we've cited where they planted bushes and trees and so forth on an area that was dedicated to the public. And when the public came back to do something with that, they said, no, you abandoned it. And they said, no, that's not how it works. They would have to go in front of the city council and say, we hereby abandon this as a city park. The mayor can't do that. This letter can't do that. And these lot owners have no ownership interest in this lot at all. They have a use interest, an ease at the minimum, which is not changed by it being a public park. They had a right to use it as a park. If it's a public park, they still have that right to use it. Just it is a public entity, not a private.
They don't have the right to use where the lift station is as a public park.
They are using the lift station because it directly impacts their toilets. When they flush their toilets, they're using the lift station. So,
But it's not being used as a park.
well, that
It's
one
being
small
used-
part.
It's being used as a municipal utility.
Right, it's a residential use within the scope of the park, which we believe is an accepted use based on the case law of park. I think I'm over time.
I think so.
Thank you.
Thank you
Thank you for your-
thank you both for your argument.